the opposite direction. This dude kicked in the door and shot me in my back with a taser that burnt my back.
All right, we'll see what we've got here.
Whoa, that's one way to open a hearing. Before the judge can even speak, this defendant fires off claims of police brutality. Now, whether he's exaggerating or telling the truth, one thing's already clear: this man is not here to cooperate.
Here with Mr. Seahigh. Looks like it's a new domestic case involving Shannon Seahigh. I'm not really sure why he would have been allowed to have any contact with her whatsoever, given all of his case history with her. Mr. Seahigh, it looks like you're back in jail on new charges. There's some of the same similar.
Judge?
Yep.
Born on the record, I reserve all my rights under the Uniform Commercial Code, specifically UCC 1-308.
Okay, I'll note that. I'm going to quickly go over the charges with you.
The classic, I reserve all my rights under the UCC. When someone starts quoting commercial code in criminal court, buckle up. We're officially in sovereign citizen territory.
You should receive a copy of them and you can just read them yourself. But count one, you're charged with threatening Shannon Seahigh on or about the 23rd day of April 2025 in Butler County, Kansas.
That never happened.
They've not communicated what the exact threat is, but they've alleged that you threatened to commit violence or communicated with her with the intent to place her in imminent or immediate fear.
That's not true.
Okay, so I'm going to
Honestly, props to the judge. She's holding her composure while calmly explaining how the law actually works. Probable cause comes before evidence. You don't get a full trial on day one. But this guy? He wants evidence on the record right now, like he's hosting his own YouTube legal show.
cause finding with
Judge, but I'm not playing anything because, first of all, I was on my own property at my own house, and I had to explain to somebody that she has no jurisdiction in what I do over my house, or even in my house or on the property or whatever. And she called the police on me, and then the police came on my property and said, I don't know what you're here for, but with all due respect, I don't want you on my property. And then they said that, well, we got a call that said that you were being violent and that you were threatening. And I said, well, that never happened, and you don't have to talk to me. You can talk to her. And so anyway, they ended up coming up on the porch, and I opened the door again. I said, I don't want you on my porch. And they said, well, we need to talk to you. We need to find out, you know. And I said, well, I don't know what you're talking about. I'm not violent. Wasn't violent at all. And so he said, well, she wants her keys. And so I said, oh, well, I mean, okay. Well, so I gave him the keys. So I gave that dude the keys so she could have them, but she could have came in and got the keys anytime she wanted to, because there are no threats. So anyway, the police officers, after I gave him the keys, he opened the door and said, well, now I'm going to have to arrest you. He said, you're under arrest for threatening. And I said, I don't know what you're talking about. So I closed the door and I went the opposite direction. This dude kicked in the door and shot me in my back with a taser that burnt my back.
This is where things get complicated. He claims he was peaceful, gave the keys, and was still tossed. If that's true, that's serious. But here's the issue: his delivery destroys his credibility. When your story jumps from, they trespassed, to, they kicked in my door, to, they shot me, in 30 seconds, the court starts doubting.
Do that again, Judge. Do that one more time. Put the pen to the camera like you did. Did you switch something?
No, Mr. Seahigh, I did not. Mr. Seahigh.
Okay, well, anyway, that's what it is. And they ended up taking me to this place that I'm not supposed to be at because of how you and some other judges and other people abused me in here. And I really appreciate being in jail. And I want to let you know that you know for a fact that I'm the one that gave those videos out, and I reported how those babies were getting killed and blood was being spread all over the wall. I mean, you've seen the video. You admitted you did on the
entered full broadcast mode. He's not just defending his case, he's accusing the entire justice system of covering up child killings. This is no longer about bond. This is about control of the courtroom.
Other court dates. So what is this, Judge? Are you against me having my own property? Are you against me exposing everybody for killing kids? For and on the record.
Mr. Seahigh, all I'm doing today is
Please stop moving your hand to the camera. You're doing that intentionally.
No,
stop doing that.
No,
you were told that I'm not
Mr.
supposed to be in this
Seahigh,
jail.
I
You know
don't
for a fact I'm not supposed to be here. Where's the evidence at? For
Okay,
and on the record.
turn off the audio. Now. Mr. Seahigh.
Interference, threatening to kill a cop. Whether he believes he's being persecuted or not, those are heavyweight charges. And trust me, judges don't play when law enforcement becomes the victim.
Hi, in count 2, you're charged with battery against a law enforcement officer, a Class A person misdemeanor. If convicted, it's a maximum of 6 months, $1,000 fine. In count 3, you're charged with interference with the law enforcement officer, resisting arrest. If convicted, it's a level 9 non-person felony. In count 4, you're charged with threatening a police officer, Cody Marvin. It is charged by the prosecutor's office as criminal threat, a level 9 person felony. If convicted, you could receive 5 months up to 17 months with the Department of Corrections, up to $100,000 fine. I imagine count 2 through 4 are incidents that are caught on camera, as most of the officers wear body cams. Probably not count 1. That will have to be the statements of Shannon Seahigh as to any reporting of any threatening statements by you or actions by you. I'm going to enter not guilty pleas on all of the charges. I'm going to schedule this case for an immediate preliminary hearing at the first available date I have, as well as I'm going to review the probable cause affidavit that should be submitted by today by the.
This prosecutor didn't just bring paperwork, she brought receipts. Multiple assaults, disorderly conduct, past jail time. When your rap sheet is longer than your defense statement, bond is not going to be friendly.
Prosecutor's office for e-filing so that I can determine whether or not they had probable cause for an arrest, and then give you a full hearing on May the 28th at 10 a.m. Now I'm going to set bond for you, and I'm going to ask for a recommendation from the state.
Yes, Your Honor, and the state is recommending a high bond in this case, as may be determined by the court. As part of special conditions, the state would be recommending no contact with any endorsed witnesses or alleged victims, that the defendant can take prescription medication and no drugs or alcohol. I believe the court has already indicated some familiarity with the defendant on the record here today. Additionally, this appears to be a defendant with a history of adjudications and convictions the court may consider relevant. Disorderly conduct and at least 2 battery against the school employee adjudications, as well as convictions for disorderly conduct, misdemeanor assault, domestic battery, criminal restraint, and felony interference with law enforcement. Pursuant to the affidavit, this appears to be a defendant who attempted to barricade himself within a residence, as well as threatened to kill multiple individuals, including at least 1 law enforcement officer. And it would also appear that there is another Butler County case, Butler County 21 CR 457, which does appear to involve a journal entry of judgment of direct contempt of court signed by Chief Judge Rickey. And in that case, it would appear that the defendant was convicted of battery, in which the victim was a detention deputy.
Okay. I'm sorry, what was the amount that you're recommending?
Your Honor, the state is prepared to defer to the court as to an appropriate amount. Certainly, the state would not be opposed to a $7,500 cash or surety bond. However, given the particular facts and the history of this defendant, the state does respectfully suggest a much higher bond is appropriate.
Okay, well, I'm gonna set his bond at 10,000 cash or surety with GPS. Absolutely no contact whatsoever with Ms. Sehi. And I assume she still has his child, but I don't know. I'm actually surprised if they were in contact or living together. If he had remained attentive and leave the room here this afternoon, I would have asked him for any statements he wanted to make about bond. And I probably would have asked him about his living situation and any potential no contact orders with Shannon Sehi. I'm going to assume, since he's not charged with violating a no contact order of any kind, that they were allowed to resume cohabitating, either as he flattened his time or his probation expired or someone lifted no contacts. It's been a while since I've had any cases with Mr. Sehi. My cases with him were disposed of rather quickly. But at any rate, that's the bond. I gave him an expedited, this is actually a preliminary hearing, not a control setting. I don't know if Mr. Watts will have a conflict with representing him. It seems like maybe Mr. Favre has been his attorney previously. So if Mr. Watts does, he can forward the case to Mr. Favre.
And Your Honor, what I would tell the court is that journal entry of sentencing in Butler County 21 CR 457, it would appear that that journal entry does make reference to Mr. Favre, and in response to the court's earlier inquiry, it would appear that the court did order 6 months in jail, but that the defendant was awarded credit for time served.
Okay, so essentially flattened his sentence. Yeah. Okay. Now,
with GPS monitoring, honestly, that's generous given the chaos. The judge even bans him from holding a pen angrily at the camera. That's a first. Clip 9. This judge has jokes. She basically said, "Next time, you won't see my pen, so maybe you'll behave." That's elite level sass, judicial edition.